Well, the boys around here don't listen to the Beatles run. Old Bo Cephas threw a jukebox needle at the honky-tonk where their boots stomp all night. What? That's right. Yeah, and what they call work a digging in the dirt. Gotta get it in the ground before the rain come down to get paid, to get your girl in your four-wheel drive. Yeah, the boys around here drinking that ice-cold beer, talking about girls, talking about trucks, running them red dirt roads out, kicking up dust. The boys around here sending up a prayer to the man upstairs. Backwoods legit, don't take no lip. Shoot a back, shoot a back, shoot a back, a spit. Oh, heck. Well, the boys around here, they're keeping it country. Ain't a damn one know how to do the Dougie. No, I'm not in Kentucky, but these girls around here, yep, they still love me. Yeah, the girls around here, they all deserve a whistle. Shaking that sugar sweet as Dixie Crystal. They like that yawling southern drawl and just can't help it 'cause they just keep falling for the boys around here, drinking that ice-cold beer, talking about girls, talking about trucks, running them red dirt roads out, kicking up dust. The boys around here sending up a prayer to the man upstairs. Backwoods legit, don't take no lip. Shoot her back and shoot her back and shoot her back a hit.
Let's ride through the countryside. Let's ride down to the riverside.
Hey now girl, hop inside. Me and you gonna take a little ride to the river. Let's ride. That's right. Lay a blanket on the ground. Kissing in the crickets is the only sound. We out of town. Have you ever got down with a do you wanna get down with a girl, you gotta get down with the boys round here, drinking that ice-cold beer, talking about girls, talking about trucks, running them red dirt roads out, kicking up dust. The boys round here, sending up a prayer to the man upstairs. Backwoods legit, don't take no lip. Shoot her back and shoot her back and shoot her back. I'm one of them boys round here, drinking that ice-cold beer, talking about girls, talking about trucks, running them red dirt roads out, kicking up dust. The boys round here, sending up a prayer to the man upstairs. Backwoods legit, don't take.
Hello?
Hello. Everybody's here. Hold on just a second.
Okay.
Welcome to the WINGIT Call. This is the Trust Call. Today is July 7th, 2016. And just for the usual, we're not attorneys, we're not CPAs, we're not financial advisors. And for the rest of the disclaimer, please go to the wingitcall.com and click on the disclaimer tab. Let me see, where am I at? Richard, you're unmuted. Richard in California, you are unmuted. And Richard in Texas, I'm going to unmute you. So if you'll just mute your phone, and then we'll go from there. Take it away, Richard in California.
Thanks, Rick. From time to time, I wanted to have a call today because I want Richard in Texas to explain some inquiries that I get from time to time. And I thought that there were three important things that I wanted to raise today. that I want us to go over, and I'm going to, in a minute, let me summarize them, but after Richard is on, if he wants to stay on as long as he can, then after that, I want to take care of a couple of housekeeping issues, but let's bring Richard on now. The three, I get calls, and the purpose of this is to make people who have made the decision to have to obtain their trust through Master's Trust, I want to make them comfortable in that decision. And also it might make people that are on the fence about what they want to do comfortable about their decision, at least to give Master's Trust a shot to satisfy their trust needs. So three things that I want Richard to address today. And I thought that we had gotten past it because we addressed it about 2 weeks ago. And that's the issue of, and I thought we had gotten through it until I got a call yesterday about it, but it's the issue of statutory versus non-statutory trusts, because I get calls all the time, is Master's Trust a statutory or non-statutory trust? So I would like Richard to address that when he comes on. The other issue that I get from time to time, people inquiring, is that, and this is a lot of information that's out there that I swear to goodness I don't know how people weed through it with all the information. Some of it is good information maybe, and some of it is just nonsensical. But this, another issue that's come up is whether Master's Trust will not be valid as a trust because of the new laws of this, whatever this new republic is going to be, and why it's nonsense to think that the laws are going to change relative to trust. So I'd like for him to address that also. Then the third thing I would like him to address, and I've gotten several calls in the last week about the misconception that you have to have multiple trusts to protect multiple assets. Master's Trust is a solid trust. You need one trust to protect all of your assets, but it seems that someone is spreading the rumor, well, I know who it is, that you need multiple trusts so that you can put one asset in each trust. So those are the three things I would like our guest speaker, Richard Ronald, to address. So I'm going to turn it over to him now.
First of all, let's talk about statutory trust. Chapter 615 of the Internal Revenue Code tells you exactly what a statutory trust is. A statutory trust is a domestic statutory trust of an unincorporated association, and it is created by a trust instrument under which property is or will be held, managed, administered, controlled, or invested, or reinvested, or operated by businesses or individuals. That's all it is. It doesn't have anything to do with the type of trust that we have, in that ours is a spendthrift trust. These are not irrevocable, created for the benefit of beneficiaries. It's just that simple, and it's totally discretionary. Statutory trusts are created by courts by operation of law, most of the time to settle real estate disputes, where someone is vested with the title and someone else is paid for it. And it's very complex. If you wish to read about it, you can go to any of the court records, and there's volumes on it. But it doesn't affect anything that we do, and statutory trusts don't even affect us. Now, number two, if a republic were to be created, the trust will be valid. Here's why. In a republic, all properties and natural resources of the republic are held in trust for the benefit of the people. A trust law creates the republic. It created the Constitution. A preamble of the Constitution is a trust statement for the people, or laws held for the people. Trust law began in 1588 1533 under Henry VIII. And it's valid all over the world. You won't find a country that doesn't accept trust law, nor will there be any exceptions other than maybe communism or a dictatorship, but that's it. So it's really not worth going into, and it's really not worth addressing. Now, as far as multiple trusts are concerned, the Internal Revenue looks at multiple trusts as simply an alter ego. There's absolutely no reason to create multiple trusts to hold assets, because the irrevocable spendthrift discretionary trust is immune to a turnover order. A judge can't issue a turnover order against one except through fraudulent conveyance. So there is absolutely no reason to create 3, 4, 5, 6, 7, 8, 10 trusts and put a vehicle in one and property in another one. That's additional bookkeeping and an accounting nightmare. Because if you have 10 trusts, you have to do 10 tax returns. The one return will not suffice for each one of them. Every one of them needs an EIN number, and every one of them has a tax return. And I doubt seriously that you'll find an accountant that will even think about doing tax returns for that type of a situation. Also, trusts must be non-grantor trusts, or they are alter egos. If a person creates a trust, manages the trust, and is the beneficiary of a trust, it's not a trust as far as the Internal Revenue Service is concerned, and it has no protection from liability. It can be sued. It pays taxes. It has income. It has all these things. And that's just kind of a basic overview of what Richard asked me to discuss. But there are many types of trusts. There are resulting trusts. There are trusts that are set up for aged people and incapacitated people, whereby a trust is created to hold their funds, where a trustee can pay for things for those people because they can't do it themselves. Sometimes parents die and a resulting trust is created for an infant to take care of them. Those are specialty trusts. There are dozens of different types of specialty trusts, but that's not what we're concerned with, and that's not what we offer. Your documents are purchased from a company that's owned by an attorney, the Rosen Law Firm out of Houston. And it's very important that you understand that when you purchase a trust, you want to purchase it from an attorney or a company in which an attorney owns and creates the document, because it can be construed that the document is not a legal document if you have it. And the reason is this. The law is very explicit. Only a licensed attorney, member of a state bar association, can produce a legal document. Otherwise, it's not a legal document. People will argue and say, well, yeah, you're going to buy it because it's some kind of a document that's been out there. Okay, go for it. But if you need to defend that document, you better have an attorney that's ready to defend it. And the Rosens have a long track record of defending trust and doing trust business, and they've been around for 37 years. The other thing that's very, very important is this. Let's say that I send in an application or an information instruction form for a trust, and I just send in that application. I haven't purchased anything. The reason being is this. Until a deposit or a payment is made to or on behalf of the company for the law firm, they're not a client. So therefore, anything that is done in that document or with that trust before a registered deposit or payment has been made is you're not operating a legal document. And I would be very, very cautious about opening a bank account without a deposit down, because if the Internal Revenue Service ever looked at it, that might be considered bank fraud, because of the simple fact that you're using a document that you haven't agreed to pay for or paid for. Now, I'm not saying this to scare anybody. This is general information we're talking about. Richard has brought it up to me several times, and I just wanted to clarify it. Anybody that has purchased a master's trust has the backing of the Rosen & Rosen law firm. So you can be confident. Also, Richard Stimson, who is our accountant CPA, does tax returns for any client that wishes to use him, and he's very reasonable. Most of the returns are zero returns, but if you have an EIN number, you absolutely must file a federal tax return. And if you haven't done one for 2015, which was last year, you need to get hold of Mr. Stimson and have him file one, even if it's a zero return. The regulations say you have to file one if you have an EIN number. If you have a trust and you have yet to get an EIN number, then you don't need to. Many people over the years have bought trusts or made arrangements to put a deposit down on, and then they instantly get an EIN number without the knowledge that, well, the next year they're going to have to file a tax return. It's not complicated, but it's a zero return, and trust returns are done on 1041s, and they're not easy forms to fill out. They come out zero returns if they're done right, because they're not subject to extraordinary dividends, and taxable stock dividends are not income to the trust, and trusts are not subject to capital gains. So there's very little that a trust could be accosted with tax-wise. In fact, I can't think of any. I'm sure Richard Stimson could, but I can't. The other thing that you need to be very cautious about, if a person or a trustee receives funds from that trust, it's income to them. All income that comes into the trust goes into the corpus, and those funds are held tax deferred. That means there's no tax on those funds. The expenses of the trust and all of that are paid for out of that fund. But once the funds are distributed to an individual or a beneficiary, then that individual has a taxable income from the trust that must be reported. Now, I know I've gone afield, and I'm sorry that I did, and I apologize. And that's about all I have to say. And I hope I've covered everything for Richard, and I appreciate the opportunity of being asked to clarify a few points. Thank you very much. And Richard, if there's anything, just give me a call.
Thank you, Richard.
You bet.
Jerry, you there? Jerry?
Yes.
Oh, sorry. Are you? I just wondered if you were still there.
Absolutely.
Do we want to do a short Q&A or?
Well, yes, we can. You caught me peeling onions. So let me wash my hands, and I'll step to my computer. I thought Richard, too, was going to talk longer. Hold on.
Yeah. Okay. Let me take care of a couple of items. Again, we have available to the WINGIT group what I'm going to call a layaway plan. It's the plan that the 10% down that we still can do as long as it hasn't RV'd. But I want to ask a favor that people who get the application, I want to be real clear on how you get the application, because there's only going to be one application accepted, and that there's a code on that application that identifies that it's going to be a 10% deposit account. And the way you get there is to go to masterstrust.com, go to the home page, find the little piggy bank in the lower right-hand corner, and attached to the piggy bank with a chain is a lock. And if you click on the lock, not the piggy bank, but if you click on the lock, then it opens up to a PDF or a Word version of that application. So the other thing that I want to make sure that we do is expedite it as soon as possible, because if that application is sent to Texas to any of those addresses like is in the application, it just delays it. So the email to send the application to is, because I want it to come into my iPad, is rth6996@gmail.com. And that's RTH is Romeo Tango Hotel, RTH6996@gmail.com. If there is a need to fax, I have a fax number, and I'll just give you that also. And that's 949-258-5517. Again, 949-258-5517. And if things can be sent to that address, either the fax or the email, it will expedite it tremendously. Jerry, you back?
Yep. So *2 to raise your hand. *2 to raise your hand. Let me put Bluetooth in. I was prepping a little potatoes and onions for supper. All righty here. I have no idea who this is. There's no caller name, no phone number. It's just blank. So you're open. Come on down. Hello.
That me?
That's you. Who are you and where are you from?
I'm from Minnesota.
I don't need a first name. Just where you at.
Well, we spell your last name a little different than you do.
Okay.
MC in Minnesota. I thought
Okay.
it was a regular Denard call, so you could. I tried to put my hand down, but it wouldn't work.
Oh, okay. Well, I can do that for you, unless you got a question.
Okay. No, nothing about the trust.
Okay, very good. Washington 301. Come on down. Hello?
Can you hear me?
Yes, go ahead.
Oh, thank you for taking my call. Really, really do appreciate all you all's calls. My question in regards to the trust, when I want to distribute funds to a beneficiary associated with the trust, do I need to concern myself with like the maximum amount that they can get in a particular year, like that $14,000 or anything like that?
Interesting you should bring that up. There was a question that was answered today by Richard Stinson. We have too many Richards going on here, but Richard Stinson, Richard Ronald, and myself. Monies paid directly to a beneficiary are going to be taxed. You have to look at money as being paid directly in the name of the beneficiary will be taxable income to the beneficiary. Monies paid on behalf of a beneficiary. So, for instance, you have a son or daughter in college. Monies paid to pay the school, pay the dorm, pay expenses to third parties on behalf of the trustee, and generally speaking, there's no minimum or maximum.
Okay.
So if you can buy clothes for the beneficiary, but if you said here's your allowance of $2,000 for the month. I'm making this up, and you have to pay books. That's going to be taxable. But if you use the trust account to buy books, or even a beneficiary's home or rent, pay it directly to the rental company, pay the utilities through the trust account. The things paid on behalf of the beneficiary is not taxable income to the beneficiaries.
Awesome. Thank you so much. See if I can put my hand down.
And further, just to go a step further, a car purchased by the trust and endowed into the trust, that the beneficiary can drive that car, and that's not taxable. The insurance can be paid on that car as long as it's paid to the insurance company and not given to the beneficiary to pay their own bills.
Okay, I'm multitasking here, so if there's a delay, it's my fault. Oh my goodness. I'm going to really say this wrong in a redneck way, but
this is me.
That's you, Ephrata, Pennsylvania.
That's me. It's Ephrata.
Okay, Euphrates works for me.
Yes, it's our Pennsylvania Dutch dialect. I was just wondering I know that you had tentatively talked about having a meeting or a webinar at one point. Did we miss that? Did you already have one, or are you still planning to do one?
No, what we did is it's very hard to plan an event like we want to have until we have specific dates. And what we were going to do was have various people. That we're going to have one in Dallas. Then we thought better about it and decided we were going to tape some things. In the website, we made some changes to the top bar. And if you go to masterstrust.com and look at the top bar, there's trust tax and trust law. And in there are some the videos there by Paul. There's some PowerPoints, and then a talk by Richard Stinson, who is the trust accountant that lives just outside of Dallas. So that's what we've done so far. Now, I have brought up the issue of having an event, at least one, probably in Dallas, and it's not any reason except, well, we California people don't to get down into Texas, but we will. But we want to have it there because it's easy to get to. A lot of people can come. We have a lot of people in the southwestern part of the United States, a lot of people in Texas, and our thought was that we would have one fairly quickly after the RV, and we can go through a lot of things that we just can't do on these kinds of calls.
Well, I would love to go to Dallas. That was my first trip when I was a young girl. I love Texas, so I'm there.
Okay.
Well, I don't know. Can you do the two-step? Can you do the Dougie? And are you a redneck?
The two-step. I'm not sure about the Dougie, whatever that is. But I can two-step.
As soon as we know what we're doing, I love Dallas. I'm kidding, but I spent a week over 2 days in.
Hey, Richard.
Middle of Odessa. Yeah.
Whatever you're doing is pretty noisy.
I'm not doing anything. I'm sitting here. I'm not moving.
Somebody else that's unmuted then. There, right there. Got it. Sorry about that.
It's all right.
All right, go ahead. I'm sorry.
That was it. We'll let everybody know the minute that we that we decide, but I would say that we will have something in Dallas fairly soon after the RV.
Great, thank you.
Yes, ma'am.
Thank you, ma'am. Let's see, put that hand down, and we're going to go to Payson, Arizona, 928. Come on down.
Yes, this is Bucker in Arizona, and I would like clarification because I was on another trust call that they insist that you have to have a trustee's name on your bank accounts or it doesn't constitute an irrevocable trust because you're signing your own checks. And I understand that with your program, Richard, that you can sign your own checks and still have trustees involved, but is it because of the spendthrift portion that you don't have to have someone else signing your checks?
Can I take a stab at that, please?
Sure.
Okay, so the first thing that you need to verify, if it's an identical trust, this is a irrevocable, non-discretionary, non-grantor spendthrift trust, and you've got to have all right, let's hold on here just a second.
Okay.
Oh, that's you. Okay. You had a lot of background noise there, ma'am. Sorry, I muted you out for a second. It has to have those, my apology, it has to have all of those things together to make it the type of trust that we were talking about right now. If you don't, it's not the same type of trust, and so you're not speaking apples to apples. Let me get back here and unmute her.
Okay.
Okay, go ahead. I'm sorry.
I know that it is irrevocable. It's a Wyoming trust, if you know anything about that. But I don't know about all the other non-discretionary and all that stuff.
Well, that's those together is what makes the combination of everything is what makes this particular trust the way it is. And if you go to the masterstrust.com, you can look up the letter right on the front. It's an irrevocable, complex, discretionary spendthrift trust. And if the other one isn't exactly like this, then it's not apples to apples. Yeah,
no, I understand that.
The only
thing,
even more basically, let me. I would never have a trust where I wasn't in control of my trust.
Exactly.
Where I wasn't the trustee of the trust, so that I could conduct the business of the trust. I would never go to somebody. I mean, I had a meeting recently with a woman who the family set up the trust, and it was a couple of $100 million trust. And she was wanting to set up this trust, and we were talking about it, and the attorneys are the trustees of this trust. She has to beg the attorneys to get any money out of that trust that's not already provided by her family. So it doesn't, the trust doesn't have to have all the elements of master's trust, because I know of certain family trusts and revocable trusts where you are the trustee and you have to make the business decisions, and you're the signer on the checks. But that's the first thing that would be a red flag to me, because if this trust could theoretically be set up, and it's just dangerous to do it, to where you have a party where you should be the trustee, but that party is a trustee and both the compliance overseer, and you're a beneficiary, and it was set up that way. the trustee and the compliance overseer could just just throw you out. So the first thing is that you don't want to be in any trust. It doesn't have to be this one, but don't be in any trust where you are not in charge of your own destiny.
Okay. Well, their logic is, and they say you are still in control of your trust. It's just they must sign the check. You can keep the checkbook with you, and they have to sign it.
Oh, no.
But
they want control of your money.
Yeah,
That's
their logic
giving them control.
is that if your name is on the checking account, they can sue you if you've had an auto accident that creates, a lot of problems for people and so forth. They can sue you, and but they can only get that one item that's in that one trust. They can't take everything you have.
No. See, that was the purpose of that. That was the purpose of the first 15 minutes or so. Okay. Best example in recent years is of a trust protecting assets is our buddy O.J. Simpson. He didn't have multiple trusts. He had his Florida homes, his California homes, his NFL pension, his Florida cars, his California cars, his memorabilia inside of a trust that had to have the same elements of this trust. And when the Goldmans got their multi-million-dollar judgment against him, the judge couldn't issue a turnover order to that trust to collect one dime. Now, here's the thing. I can see if this is a grantor trust, you want your name on the bank account. You've got to have your name on there. There's no logic that can extend to me to where I want anybody to sign anything. This is a non-grantor trust. This trust was not put together accidentally. It's been ongoing development for years and years and years and years, with frequent updates to it. There were just some updates made to this within the last couple of weeks. So there's no logic, that would ever have me do something where I didn't have absolute total control of my trust. And this trust cannot be penetrated by a turnover order unless you have fraudulently set up the trust. And I'll give you a couple examples of that. If you already have a huge major judgment and you're trying to hide assets, you have a lawsuit trying to hide assets, or you have an expectation of a messy divorce and you're trying to hide assets, the judge can reverse it. But under normal circumstances, you cannot, if you had everything in this trust, it cannot be penetrated on a turnover order. Even if you had someone that was in an automobile accident who's a beneficiary or a trustee driving a trust car, they can sue them, but they can't penetrate the trust because they don't own anything in the trust. They have beneficial interest, but they don't own anything.
Okay.
Even as a trustee.
Thank you so much.
Even as a trustee, that's the big kicker right there. You're not in control of anything.
Thank you very much.
Yes, ma'am.
Hold on. Jacksonville, Florida, 904. Come on down. Hello, Jacksonville. Area code 904. It's a cell phone. The last four of your number is 9891. Hello. Hello. And we'll get back to him in a minute. Detroit, 313. Come on down. Detroit, Michigan, 313. Come on down. Hello. Yeah, we can hear you. Find out what. You're listening to somebody. Hello, Detroit. Nope. Galveston, 409. Come on down. Galveston. Hello.
Yes, can you hear me?
Yes, sir. Go ahead.
Would Richard reiterate the where and we all send the 90%? And I know that we put the serial number issued to our trust, but just reiterate that process for us.
Yeah. I think you asked, and if I'm not mistaken, where you send the 90% or where you send the 10% deposit?
The 90%. Already have mine. So just.
Oh, well, what you would do is let me know that are you thinking about paying off your trust? Do you want to get your full trust?
Hold on. He muted himself.
There
you go.
Am I back?
Yeah,
okay.
You're back.
No, I have it, my trust. But I just wasn't clear on whom to make, on the 90%, because I'm going to do that, obviously, like others, as soon as we RV. But
okay.
Reiterate where we send it.
Yes. Okay. Here's the process, and this is after the RV, and even before the RV, because we've had several people go ahead and pay off their trust and get their full trust because they had reasons to do that. But the balance will be, the check will be made out to Masters Copyrights LLC, and it will be sent to my address here in California.
Okay, where we sent the deposit.
Yeah, where you sent the deposit. So then the process is that they will already have files in Texas. So the minute, and it's just going to be first in and first out. So the minute I get the deposit here, then I will alert them to put that trust in production in Texas. And then I'll collect the checks and forward the checks to them, but they will take my word that I've collected the cashier's check, and then it's going to be forwarded to them, but they'll go ahead and start the production on the trust because they'll already have files.
Would there be any issue at the RV? Because we can, my understanding, get cashier's check. Would that cause any repercussions, or should we wait till we get back to our given bank?
I'm going to have them cut me a check right there, make it out for X amount, and they don't even have to fill in the name. They can cut you a blank cashier's check, just like the bank does.
All right,
and I
very good.
I think, yeah, I mean, I think that you could do it either way. I think that if it's true that we're going to have off banks or non-bank sites, then if I'm RVing during banking hours, then my next move is to drive to my branch and walk in the other side of the bank to the private bank side and say, guys, I seem to have found some money in this account. What can we do about it over here on the private bank side? And I mean, I assume that we're going to have access to some amount of money pretty quickly, and then the balance of it over the next day or so. Just have them write a check. Just cut a cashier's check. Yeah,
that's the plan.
Right. Thank you, sir.
Thank you.
Thanks.
Harry on the web. Come on down. Hello, Harry on the web, Lancaster. He muted himself. Hold on. Harry on the web, come on down. You're unmuted. In Lancaster, California. Okay. Colorado Springs, Colorado. Howie on the web. Come on down.
Hi, can you hear me?
Yes, sir.
Oh, great. Okay. Hey, pleasure to be here. Richard, question: can you change the domicile of the trust? Is it easily done? Do I need to reside where it's domiciled or not?
No, you can. You should have a reasonable reason to domicile it someplace other than where you live. I mean, if there's a wives' tale that you should domicile your trust in certain states because of certain benefits. Well, that could be no state income tax. There's better protection for trust, but with this trust, you can domicile. There's no reason to domicile it one state over another. But
so tax is not a consideration.
Tax is not a consideration. Nope, it's not at all.
Okay.
But you're domiciled. I mean, you start out with a domicile, okay? But your domicile can change the year that, let's just say you moved. Your trust will be domiciled in the state that you filed your taxes for that year, if for no other reason. So let's say you live in Minnesota and all of a sudden you're saying, I'm crazy, I'm going to Florida so I can be warm. You move to Florida. You don't have to alert anybody that the domicile's changed, but fundamentally, wherever you file your taxes for that year will be where you're domiciled.
Okay. About the beneficiaries, so if I indicate someone is a beneficiary, and then let's say the trust purchases a car for her use, and then in a later date, that person is terminated as a beneficiary, that just means they no longer have use of the car, but the trust still owns the vehicle. Is that accurate?
That's correct. Yeah, you want the trust to buy the car and assign it to the trust. What's the word I'm looking for? Endow it to the trust, so it'll be purchased by the trust. I mean, okay.
I guess what I'm getting at is you need to be somewhat. You need to be somewhat discerning in terms of what you give to a beneficiary, because basically, I mean, if you purchase a home and you give it to, and you allow a beneficiary to use it, clearly that's potentially a lifelong scenario. So you better feel pretty confident that the individual who you're claiming as a beneficiary is going to be in that type of relationship with you. No? Sure.
Yes, but you don't. If my car is owned by my trust, so if I am no longer the trustee of the trust, and I'm no longer involved in the trust for some reason, the trust still owns my car. I guess I could still drive it until it caught up. But you're right. The trust buys the car and allows the beneficiary the use of that car. If something came up, as long as you are both the trustee of the trust and the compliance overseer of the trust, you can change that beneficiary. You can delete them from the trust, which means they lose their right. You would just revoke their right to use the trust car.
Okay. Regarding Richard from Texas had mentioned fraudulent conveyance, I'm going to turn that around. How do we best ensure legal conveyance if we're purchasing property, assets of any nature? Do we need to have do we need to contact Rosen & Rosen for virtually any conveyance to make sure it's being done properly?
No, not at all. No. What you do is, just for your own records, for the people who have gone ahead and given their 10%, they got a form. And that form was a form that it was basically an assignment form. And on that assignment form that they used for their currency, just to keep good records, you would use one of those forms to assign that asset into the trust. And then, and that's the letter of transfer and conveyance of property. So you use one of those for every general big asset that you want to put in. If it is a piece of property, the only thing that you have to do is if it's already owned and you want to put it in a trust, just do a quitclaim deed or a trust deed and assign it from the owners of the building or the property into the trust, and now it's an asset of the trust. When you're
even though the mortgage might still have your personal name on it, is that accurate?
That's correct. That's correct. Now it's not gonna. It can prevent someone from taking your. Let's just say there was a lawsuit against an individual party to the trust. Let's just say your son your son or daughter or somebody is in an automobile accident. They were at fault. They were sued. They lost. If the house is in the trust, if your cars are in a trust, if all your assets are protected in the trust, a turnover, or even if they got a judgment against the beneficiary or the trustee, they can't penetrate the trust to take your asset and take your wealth. So if you buy a car, it's easy to have it put into the trust because you just tell them, I want to take title in the name of my trust. If you buy a house, escrow companies, a couple of days before you close, will say, how do you want to vest the property? And you just say, I want to vest it into the name of my trust. Here's my address, the trust name. I'm the trustee. Here's my EIN number. Boom. They know what to do, and they put it right into the trust. The same with any commercial building.
Now, that's assuming that there's no mortgage, right? I think you and I had talked about this, and you had indicated that, hey, if you've got a mortgage, then it may not be transferable to the trust.
No. Title, registration or title has nothing to do with the mortgage. I could have a mortgage with Wells Fargo, and I could title my home into the name of Santa Claus. It has nothing to do with the mortgage. You can have a mortgage on a piece of property and assign it. That's exactly what you'd want to do.
So in essence, the bottom line is the mortgage is in my name, but I assign it to the trust, so the trust owns it, even though its name is not on the mortgage.
That's right. That's exactly right. And that's not gonna. There's no sale there. That happens all the time, and they're not gonna accelerate the mortgage because you put it in the name of the trust. Because properties put into trust all day long, all the time, that have mortgages on them. So that's not an issue.
Right. So that simple letter of transfer and conveyance, I don't think it's called on that form an assignment. That doesn't need to be notarized. That doesn't need to be filed anywhere. I mean,
no.
How do I make sure that that's
it just has to be witnessed, that's all.
Just witnessed.
Yeah, but the form doesn't do it. The form is a record keeper. So then what you would do, just to keep records clean, and this is what I do, is I would fill out the form, the letter of transfer and conveyance, but my record of that is the deed of trust, or the quitclaim deed, or the trust deed that assigns it into the trust. So then you would just attach that after you did it. You'd attach the recorded document to the back of that sheet, and now that asset is assigned to the trust.
Okay, and a quitclaim deed that only applies to real estate, does it not?
Yeah. Your car, the car would just be, you'd take title. The registration would be in the trust name. That's easy to do.
Gotcha. Okay. And
right.
Last question. Yeah, I'm sorry. Go ahead.
No, I'm going to say thank you for your questions. One more, and then we got to move on.
Yeah, I'm still kind of trying to understand the whole concept of what a trustee can use that is in the name of the trust in terms of expenses. So, I mean, if I decide I'm going to take a trip around the world, what am I doing? Am I saying that, hey, that's a personal expense? Or am I saying, hey, I'm doing that on behalf of the trustee on behalf of the trust, on behalf of the beneficiaries, because I'm exploring properties, I'm exploring business opportunities. I mean, what is the best thing to do in that scenario? Because I'm just trying to identify, gee, do I need money separate from this trust for personal expenses?
Well, now there's some of the questions that everybody's asking is if you go to the master's website, those tabs he talked about after you watch the video, there's 2 more audios there that explain everything in quite detail. The CPA did a wonderful job giving some great explanations. And also,
I did listen to that, but I didn't identify. I mean, I guess maybe I need to listen to it again, but I'm just trying to identify under what circumstance can you claim that something is a trust expense versus a personal expense, and how do you distinguish between the two? That's what I'm wondering.
Well, I'll give you just a quickie right here. Everything that the trustee does in the trust, you have to look at they're doing it for the benefit of the beneficiaries.
Mm-hmm.
So if you're enhancing the trust and you're conducting the business of the trust, and the trust is going to be in the business of real estate investment or whatever you're going to do, then if you're going to travel around the world, you're going to have to take money from the trust, and if you're just going to travel. But if you're conducting business, you can conduct the business, and the trust pays for the conduct of that business. But it's like any corporation, you just have to document your expenses if you're ever challenged. So you can and you can take a beneficiary with you while you're conducting that business, because you're gonna. I mean, you wouldn't go buy a car for a beneficiary without kind of consulting them, I would think. Although you could, maybe you would an investment piece of property. The trustee can be reimbursed or have the expenses of the trust paid for on their behalf, which includes travel, automobile. You do have to declare a portion of your automobile as personal income each year, but it's a small portion. You're going to have personal income to pay for your haircut, for instance, but your haircut of your beneficiaries can be paid for by the trust. If you want to buy clothes, you have to pay for that personally. But since in a normal white picket fence relationship where there's a married couple or with kids, so much of the expenses are going to be paid for on behalf of the beneficiaries, so that the trustee might not even have to take very much of a salary to pay for their coffee and haircut and just personal stuff. If it's important that you have to take a salary for a reason, take a salary and just pay taxes on it. The purpose of these trusts were originally gas and oil leases and stuff like that. The trust was set up to take the hit for a huge increase in the value of a capital asset of the trust, like the currency. And then over the years, you mitigate the taxes in smaller increments over the years, but it's going to be hard for the trustee not to have some taxable income, especially the trustee to have some taxable income just by virtue of the way that they have to operate the trust. If the trustee's married, if the trustee's single and they buy a house, it's a little bit more complicated than if they're married. But the trustee has to pay for things personally out of their own pocket.
Mm-hmm. Okay, thank you.
Yep. Rick, you there? Hello? Well, I don't know where Mr. Rick went. Are we dead? There?
Oh, sorry.
Oh, there you go.
I had myself mute. Anonymous on the web. Hello. Anonymous on the web. Or no, you're not on the web. You just called in. No name, no number. Hello? Hello? Okay, goodbye. Sedona, Arizona, 928. Come on down.
Jerry?
Yep, go ahead.
Hi. I have kind of like a double-edged question. The question that I have is don't have children. However, I have 3 siblings. Because I don't know what name to put the trusts in, I put them in their names. Is that something that eventually could be changed? They don't know anything about the currency. I have not told them because they think I'm nuts when I first brought it up. And so that's my concern, is that can I put it in their names or should I change it so that it's not in their names once the RV occurs?
Well, let me clarify something. Are you saying that you've set up trust for 3 people? Or am I hearing you correct?
Yeah. Yes, that's correct. I will fund it. I'll fund my own and then give to them endow amounts for their 3 trusts and then turn them loose and let them be trustees of their own trusts.
All right. So what you want to do, have you already gifted currency to them?
Nope.
Okay. All right, then do make sure that yours is set up.
Mm-hmm.
In exchange.
Mine's already set up. Mine is already set up with you guys.
Okay. Exchange all the currency into your trust.
Right.
Make a note of what your gift not your gift, but what you expect them to receive in their trusts. You would come back to us and we would set up 3 more trusts after the fact.
Mm-hmm.
And then you can endow, since you're purchasing them, you can set them up the way that you want to.
Mm-hmm.
I mean, you could remain the compliance overseer for a while and let them be trustees, and then give up that title after a while, and then you just endow to their trust. From your trust, you would make their trust beneficiaries of your trust.
Mm-hmm.
Then you would endow into their trusts, and then you would take them out as the beneficiary, take out their trust as beneficiaries of your trust. And those trusts are on their own.
Okay. One sister is in the midst of a divorce. I'm concerned for her.
I wouldn't be.
Why?
You're the buyer of the trust. Anyone has the right to form a trust.
Correct.
Okay, so you're forming the trust. So you're making the rules. So if you're setting up a trust for her that has nothing to do with community property, I think I'm getting on the edge here, but my experience says that it has nothing to do with community property, that it's a trust that you have set up for her, and you don't have to tell her about it yet.
No, I have not. I've said nothing to her.
Yeah, but
kept her in the dark.
You're making the rules.
Okay.
So what I would do would be to, if you had some concern, is set up 3 more trusts where you could be the compliance overseer and the trustee for a short period of time.
Right.
Make them beneficiaries, and then you could appoint them as the new trustee of the trust when it was appropriate.
Okay.
You're in charge. You're the one that's making the rules when you set up a trust.
Right, and that part I'm getting. I'm just concerned so that the soon-to-be ex-spouse can't get in there and start making.
There's no way he can get in. There's no way he can get into it. You're making the rules.
Unless you add, you'd have to actually add him in to be able to get in. It's just, you're not going to do that, are you?
No.
Okay.
No.
All righty. Thank you, ma'am.
Last question. Last real question. Real quick.
It has to be short.
It's very short. I've got two other trusts. Can they be absorbed into the Spendthrift Trust?
Well, the assets of those trusts can be, they can be. You want to think assets, not the trust. The trusts are not going to be absorbed, but the assets of that trust can be endowed into this trust. So if you're holding property in one of those trusts, then you just assign that property from that trust into the one that you're holding with Masters at the appropriate time.
Perfect. All right. From now on, just one question, please. We're past an hour. We're going to go a little bit farther so we can learn some more, but just one question so that we can get through more questions. Mesquite, Nevada, 702. Come on down. Hello, 702, Mesquite, Nevada. Hello, 702, Mesquite, Nevada. Nope. Moorestown, New Jersey, 609. Come on down.
Hello, can you hear me?
Yes, ma'am. Oh, you muted yourself. There you go.
Oh, shoot.
Okay,
can you hear me now?
Yes. One
Thank
question,
you.
please.
Thanks. I have a question about beneficiaries. Richard, have you, if someone who has this trust has assigned a beneficiary and then decides at a later date because that person has gone off the rails and they want to remove that beneficiary, has there ever been with the Masters Trust a challenge to that, like someone trying to sue the trust or sue the trustee for removing that person as a beneficiary, and how would that go?
Well, you would have to have, technically speaking, and this is that the beneficiaries of a trust have no claim to the assets of the trust. They have no claim to any of the actual assets of the trust. So they could bring a claim, but whether they bring in a claim again. I mean, anybody can do anything, but they don't own anything in the trust. They only have beneficial interest in the trust. And so as long as the trustee is also the compliance overseer, that trustee can remove that beneficiary, and there's no recourse.
It's never happened?
I can't say it's never happened, but I've my time with the Masters Trust, I've never heard that happen. I'd have to ask. Richard's seen, the other Richard in Dallas, Richard has seen everything, so maybe, he would say no, it can't happen. That would be his short answer. But as far as it's ever happening, but it can't. They don't have any standing. They would have to have legal standing in the trust to be able to challenge it, and they just couldn't challenge it.
Great, I thank you. Pretty please, may I ask one more question, please?
No. I set the ground rules. I'm sorry. We've been in this 2 hours, so my apologies.
I'll talk to you later, Richard. I'll ask later. Thank you.
All right, bye.
Cincinnati, Ohio, 513. Come on down.
Hey, Jerry.
How you doing?
Pretty good. How's it going, Richard? Hey, my question, is there any way that the government or the bank can penetrate your trust with bail-ins, or if the government wanted to not for suits or anything like that, but just, is it protected from everybody?
Well, one of the things that I mentioned, the bail-ins I think they can only attach personal savings account, and maybe personal checking accounts. And I think that it's only on the retail side of the bank where we all walk in. And that's why I'm adamant about getting into the private bank of Wells Fargo, to where the private bank is, as it's explained to me, is off the balance sheet of the regular bank. And a judge can't issue a turnover order against a bank account. So it's as protected as anything can be protected, especially if it's in a trust account in a private bank. And I'm not talking about even in wealth management. I'm just talking about the private bank. That's going to be my move. May not be for anybody else, but that's just my move. But I don't think I don't think we're going to have to worry about any kind of bail-ins with Wells Fargo, if that's your bank.
It will be mine. All righty, we're going on to our next caller. Chattanooga, Tennessee, 423. Come on down.
Hello, can you hear me?
Yes, sir.
Good. Thank you, Jerry. I really appreciate your show. Really appreciate Iko and you. Richard, I've already sent my application into you, and I asked you the last time, where do I send my deposit to?
Mm-hmm.
But anyway, this is Gary.
Yes, sir.
Anyway, my question is, I want to set up a charitable trust and do a lot of philanthropy. And so I want to have a person who is in charge, that he can go out to these projects and write the checks, etc. So would he be the compliance overseer, or what would he be?
Well, he would be someone conducting the business of the trust. He would be the trustee.
Okay. And then what
I would do if you were going to do that, then I would put myself in as the compliance overseer.
Okay.
And put him in as the trustee, if that's the route you're going to take.
How many trustees can you have?
Well, in a charitable trust, I mean, you generally want to have one trustee. You've got to have one person making the decisions, because if you get into multiple trustees, and you think of it, the board of directors, now you have to have consensus, and one person could hold up the trust, because you can't. I just think you should have one.
Okay. All right. Sounds real good. I appreciate you. And just let me know about my email.
Thank you, sir.
Okay.
Ladue, Missouri, 314. Come on down.
Good afternoon, everybody. I'm glad you're having this call. Thank you, Jerry. And thank you, Richard. The question I have is and I do have a trust through you all, but I'm looking at, can you put other trusts under that trust, under the spendthrift trust? Can other trusts be put under that? Say, for instance, like you was talking about the cars. Could the cars be put in a separate trust?
Well, that was kind of the purpose of this. The first part is that you don't need to.
Okay.
You don't in this trust. I mean, if someone, this is me talking, if someone is telling you to put a different asset in a different trust, it means that they're telling me that they don't trust that trust enough, that they're thinking that possibly someone could come in and take that asset if it's in the trust, but they couldn't touch anything else. I don't know. In this type of trust, that was the point of the first part of this call, was to reassure you that you don't have to do that.
Oh, okay. I missed the first part of the call. Okay.
Yeah. You can put everything that you have in this trust, and it still is not going to be subject to a turnover order. A judge cannot issue a turnover order to this trust.
Okay.
All right.
Okay, that was my
Thank
question.
you, ma'am.
Thank you so much.
Uh-huh.
Okay. Last call, Nashville, Tennessee, 615.
Hi, Jerry.
Yes, sir.
Thanks for taking the call. Richard, and you may have covered this earlier, but for purposes of this currency exchange, could I get a trust from you and then have the beneficiaries of this trust be, let's say, 10 other trusts where I would have different family members, different charitable organizations set up, and decide after the exchange how to split and diversify the proceeds, but to keep it simple up front, do it that way by getting a trust from you?
Yes, you can get. We get calls all the time where people talk about the fact that they've gifted this money to 5 or 10 family members, and now they're concerned that they don't want to worry about all the exchanges and the people are going to have to pay taxes. And I said, well, just go and collect all that back. Exchange everything into one trust that you set up now.
Okay.
Because the important thing here is that your currency has to be an asset, has to be assigned into the trust prior to the increase in value of the currency.
Got it.
So get one done, get that assigned in, and then exchange everything into one trust, and then step back, take a breather after this is over, and then set up charitable trusts or other trusts for family members that you want to do. You bring them in as those trusts in as beneficiaries. You endow to those trusts, and then you release them as beneficiaries out of your trust. It's exactly how you do it.
And all the distributions, different amounts, can all be done post-RV as long as it's done the way you just described.
That's correct. It's an endowment from one trust to another is not a taxable event.
Thank you very much.
Yes, sir.
Thank you, sir.
Thank you, Jerry.
So, you want to give a quick summary, or you want me to do it?
Well, I think my concern is there's just so much information out there that our clients are hearing. I want to make sure that they understand that we want to make them comfortable that they've made the right decisions. Bring up these issues as I hear about them, because I have people call me up in a panic and about this and about that. I had one gentleman the other day. He said, "Now I hope I've got enough money to go ahead and set up multiple trusts so I can put all my assets in them." And I said, "What are you talking about?"
Yeah.
He says, "Well, I just think we have to set up another trust so I can put all my assets in, individual trusts." And I said, "You don't have to do that. You don't want to do that. We're in the business." I was hoping Richard would say it. Richard, we're in the business of selling trusts, and here we are telling you that you don't set up these multiple trusts.
Right. You've got to go back and on the masstrust.com website, the attorney opinion letter. Here, what a lot of are thinking about is, you say, I have a spendthrift trust. What you're not telling them is the rest of that. It's an irrevocable, complex, discretionary spendthrift trust. So when you say just spendthrift trust, well, that sends attorneys into a tizzy. Oh my God, you've got to have 10 different trusts, one for each one. And that's where the problem lies.
Yep.
So please go back and look at the attorney letter on the front, and it gives a breakdown. And one trust will do everything that you want it to do and is perfectly legal and will protect everything that you want as long as you haven't done anything illegal. I would say immoral, but that doesn't cover that, just illegal. and you're covered. So the best I can suggest is going through there and read the different tabs I'm sitting here looking at the website. You've got what is a trust, what's a spendthrift trust, basic information, history of the master's trust, case law update. And it tells you if anybody tries to take you to court or sue the trust, or somebody tries to break into it, Rosen and Rosen will be right there at your side. And if I'm not mistaken, if a government entity is trying to break into it, they will represent you for free, because this goes against everything that they've worked towards, which is perfectly legal, and they're not going to have somebody try to break into it. They will fight tooth and nail. So, and as I was explained to, there's some Jewish gentlemen, and they take this very seriously, and their fangs come out. So please go to the website, read those tabs, watch the videos, and some of the questions that we didn't get to, I'm thinking they might be answered. So there's the summation. You've got the proper trust. It's just that you're not, when you say spendthrift, you're not giving the whole title to the trust protection-wise, and then they're going, oh no, that's not good for you. You're okay. Relax.
See, in fact, and I'll end with this. If you did go and tell most attorneys that some bunch of idiots were telling you that if you had a irrevocable spendthrift trust, that it would offer asset protection and tax deferral, and most knowing attorneys say, well, no, that may not be right. And you know what? They're right. It wouldn't be right if you just went and told them it was a spendthrift trust to get a second opinion. So Jerry's right. You have to go through the non-revocable, complex, non-grantor, discretionary trust with spendthrift provisions. You have to, all of that describes this trust. Not statutory, it's not non-statutory, it's neither. And those terms don't mean the opposite of each other. So you're the right place, I believe. I know I'm in the right place. I think Jerry thinks he's at the right place with his, and so that's where we are.
There's a lot of misinformation out there, and I'll say this: there's a lot of people that are going to have egg on their face. That's all I'm going to say about that. You'll hear about it after the fact. You're okay. So I missed this at the beginning, and I'm extremely sorry, but we'll all just take a knee. And Lord, thank you for the guidance. Thank you for the information that you have brought to us, guided our lips, well, at least mine anyway, because mine get carried away from time to time. And I thank you for the many blessings, not only for myself, but for all of my brothers and sisters out there who are in dire need, and you hear our plea, and we feel like we're Moses in the desert. We just haven't been there 40 years yet, but you hear our plea and our cry. And I ask in Jesus Christ's name that you please hear our prayer and bring your blessing down so that we can help out our brothers and sisters. Amen. So that being said, as I've always said, Iko, what is it you say? Goodbye.
Thanks, Jerry.
The conference is now completed. Goodbye. Welcome to the conference. Please enter the conference.